call to order the State of Rhode Island Coastal Resources Management Council to order. This is our semi-monthly meeting. Today is Tuesday, February 11, 2025. I would ask that the record reflect the council members that are present, as well as CRMC staff members and our legal counsel being present as well. Our first matter on the agenda will be approval of the minutes of the previous meeting, that being January 28, 2024. I would ask for a motion to approve them unless any corrections are needed.
Motion to approve.
Motion's been made. Is there a second?
Second.
Motion made and seconded. Any discussion? Hearing none, all in favor say aye. Aye. Anyone opposed? That motion carries. Staff reports, Mr. Willis.
Thank you, Mr. Chair. I just have a couple of brief announcements to make. I think at the last meeting, I had mentioned how we have put out a solicitation for volunteers to reconstitute the Fishermen's Advisory Board. We have done that and have gotten a handful of interested folks that are looking to get onto and what we would constitute as the new FAB. As we vet those, we will bring a list up to you all for ratification in the very near future. Staying on the offshore wind theme, we continue to work with South Coast Wind, Ørsted with their what's called the old Bay State lease area, which they're calling now Starboard Wind, and also Vineyard Wind over in the southeast corner of the area that's called the Rhode Island and Massachusetts Wind Energy Area. So we continue to have a lot of interaction with the developers for offshore wind, regardless of the administration's stance on that, because these developers have already gotten a number of their approvals or are close to having their approvals in hand, which means they can move forward. So we continue to meet with them and coordinate on those projects. And then lastly, you're all aware of some of the issues on the Washington Bridge with the demolition that happened last week. CRMC staff was on site. It happened on Sunday evening. CRMC staff was on site the following morning to help coordinate the DOT staff to make sure environmental controls were in place. We've coordinated with the DOT staff and are getting, if not daily, pretty much every other day, updates on what's going on with the demolition project. So we post that information to the website if you want to see some brief updates there, but just to let you know that we are coordinating with DOT on their demolition project on a pretty much daily basis. Thank you, Mr. Chair.
Any questions of Director Willis? No. Subcommittee reports.
Mr. Chair, the Rights of Way Subcommittee met earlier today to discuss a couple of different matters, one of which was what are the next steps for the Buttonwoods potential designation process. We have some actions that legal counsel is going to follow up on in terms of finalizing a memo on that, as well as we discussed a potential site, potential final designation of Everett Avenue in Westerly, which has a history in front of this council that dates back to the 1980s. We have some follow-up action for that at the subcommittee's April meeting that they'll take up the Everett Avenue matter then for further designation process questions.
Any questions of Director Willis as it relates to subcommittee reports? Okay. We'll next move on to the applications which have been out to notice and are before the council for review and action. First one being 2024-09-080 VTG CAPITAL LLC. It's an application to construct and maintain a residential boating facility consisting of a 4-foot by 42-foot fixed timber pier, 4-foot by 20-foot aluminum gangway, and 8-foot by 35-foot, which equates to a 280 square foot terminal float. The facility is proposed to extend 74 feet seaward of the mean low water mark, requiring a 24-foot length variance to our Redbook 650-RICR-20-00-01. Section 1.3.1 D11 L or a 1, I'm not sure. L2. The structure will be a shared facility for lots 166 and 244. which will be tied together for purposes of any assent and has been designed per section 1.3.1 D11E, located at plat 26, lots 166 and 244 at 183 Mathewson Road and 2 Blount Circle, Barrington, Rhode Island. And Tracy, you have this for us, please.
Thanks, Mr. Chair. As you stated, it's a fixed pier ramp float design in the Barrington, in the Warren River. It's on the Barrington side, just south of the confluence of the Barrington and Warren Rivers. There are seawalls surrounding the area. There is residential boating or marina nearby. There's waterfront development on the other side of the Warren River as well. Very busy area, strong currents, but lots of boating. This application went out to public notice in November. It ended December 19th without comment. It was scheduled for the December 20, section 1.1.6 category A dock meeting. And in preparation for that meeting, I realized that I had missed the property line extension running north-south. On the plans, it's the lot 4. They have several oddly shaped lots in a row here, and lot 4 shares a boundary with lot 244 that runs north-south, essentially cutting off anybody that put a pier out in that shoreline. So the only affected abutter is lot 4, and so it was conditionally approved at that dock meeting, provided we got a sign off from that abutter, which would waive any variance to that. We did receive a sign off from that abutter in early January. In the intervening weeks, we also received comments from the owners of lot, I believe it's 8. Yes, lot 8, which is north of the 2 lots that are proposing to share this facility site. They have an existing dock, and they are objecting to any dock in that area that's too close to their existing facility, their comments, and they wish to speak at any hearing. The dock is pretty standard construction. For shared lots like this, they're allowed up to a 300 square foot float, terminal float, and they're proposing 280. The length variance for 24 feet is pretty consistent with our variance criteria. We would have approved administratively, actually conditionally did, as it achieves 2 to 4 feet of water along that float, which is actually inland of both neighboring facilities already. It was brought back after we received the letter of no objection and the comment letter to the January 29th category A dock meeting, where it was recommended to forward it to the council for hearing. I recommend no technical objection. I already recommended approval at the dock meeting. When reviewing the comments, I don't believe they've met the substantive criteria. It's a pretty standard dock location, and in my opinion, there's ample room to site this facility, given the offsets. And we have specific stipulations that we include on shared facilities. I did put them in the staff report. So if the facilities to be approved, I recommend that the council includes those as well, which refer to tying those lots together for the purposes of one lot only, one dock only on those 2 lots in the future.
Any questions of Tracy from the council?
I have a question, but maybe not so fast, maybe for the council. What is the policy on receiving letters after the close of public comment? So if you have a close of public comment and you're not really closed, then what is the point of saying the public comment is closed?
I can answer that, Mr. Flynn. It's a little complicated, forgive me. Back in 2006, I believe, this council gave staff the ability to look at certain applications that would normally be heard up here and have them heard at the staff level administratively. That came with a lot of discussion from the public, a lot of discussion from the council, and one of the things that was agreed upon at that time in the passage of that rule was that if we staff got any objection for any of those types of activities, we would bring that application up in front of the council. Tracy has exactly that issue where we did receive a comment, albeit after the fact, But it was basically an agreement at that time that if we did get an objection on an application, even if we can handle it administratively, we bring it up to the full council for their for that objection.
I have a question, Mr. Chair.
Sure.
I see in the staff report that this is supported in general, this shared dock facility. And that if these are no longer in common ownership or controlled together, that the right for this shared dock transfers to the new landowner. Does that include access over the land to get to the dock?
Typically, that's an agreement between the landowners. They're currently in common ownership right now. Over the years, I've seen various iterations of that agreements between different landowners that allow use to that. An asset will be recorded on both lots. That this dock serves both of those lots. So each will have its own if anyone does a title search when they purchase it. We don't necessarily get involved in how they access it, per se. But it's certainly something you can feel free to.
Is this something that's happened fairly commonly in the past, these shared dock facilities?
I've probably, I'd say I've done about half a dozen in 25 years. So every few years we'll get one, which the program is, that's a goal, is to, you know, cut down on the amount of facilities out there. So it's always a good thing. They are out there.
Any other questions from the council? Is the applicant or their representative present this evening? Please come forward.
Good evening, my name's Tom Gay. I'm the property owner of 2 Blount Circle and then the manager of VTG Capital, which owns 183 Mathewson.
I'm Todd Chaplin from Mount Hope Engineering.
What's the last name, please?
Chaplin, like Charlie.
You want me to swear them in?
Sure.
Gentlemen, I'll have you both raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And I hope might be repetitive. I'd ask that you please state and spell your name for the record.
Thomas Gay, ThomasGay.
Todd Chaplin, TODD CHAPLIN.
Thank you.
Thank you. You've heard Ms. Sylvia share her comments as it relates to the application. Is there anything that you wish to add to it?
No, as to Ms. Reynolds' comment, the 183 Mathewson Road is on a right of way that does terminate into 2 Blount Circle. So the idea of access would be through, there's already a right of way access on that area. The plan would be if a property was ever sold to reserve an easement for those properties. My goal is actually my parents, my dad's retiring, are going to move in next door and hopefully provide some well-needed childcare for our 2.5-year-old. So that's hoping to happen this fall. But the goal is to, you know, maintain this property and the stock facility for our family. When we designed it, working with Todd, we tried to give both of our neighbors as much room as we possibly could. And I think through Tracy's comments, we accomplished that. So my hope is that the council would look favorably on our application.
Questions of Mr. Gay or Chaplin from the council?
Yeah, Mr. Chaplin, do you know what the distance is between the dock to the north of this property and the proposed dock?
I do. So the existing dock to the north is 27.5 feet off of the common property line between us. And he has 40 feet actually to his north. So he could have actually built his dock a little further north if he wanted some more room there when he built that. We are holding about 44 feet to that north property line, and we have about 72 feet between the 2 docks.
That's what I thought. Thank you.
Seems more than ample, I think.
Can I ask a question?
Sure.
But that dock has been there a long time.
Yes.
Okay. And did I hear from staff or maybe from you that Is your dock gonna be shorter in length than that dock?
It is just a little bit shorter.
It's almost the same.
It's almost the same, but it's a little bit shorter. It's just inside the stone revetment to the south and the fixed dock to the north.
Any other questions of these two gentlemen? All right. Is there anyone else present this evening that wishes to speak in favor of the application? Is there anyone present this evening that wishes to speak in opposition of the application? Okay. Is the council in a posture to make a motion?
Mr. Chairman, based on the report of staff and the staff's presentation tonight and the testimony from the applicant and the applicant's expert, I would move to approve the application and the variance required for this application with the stipulations proposed by staff in its report.
Thank you. Motion has been made by Mr. Izzy as stated. Is there a second?
Second.
Second by Mr. Gagnon. Any discussion? Having none, I will poll the council. Mr. Flynn,
Aye.
Mr. Izzy,
Aye.
Mr. Russolino.
Aye.
Mr. Gagnon. Ms. Reynolds.
Aye.
I too, Raymond Coyer, vote aye. Application has been approved. Thank you.
Thank you very much.
Thank you. Thank you.
Next on our agenda would be enforcement matters before the council for a status conference. First being 23-0047 Odie Realty LLC. Indicating the alleged violations are unauthorized earthwork, parentheses, filling, removing, and grading, close parentheses, on a coastal feature, construction of a riprap retaining wall on a coastal feature, construction of timber structures on a coastal feature, and cutting of natural buffer zone vegetation. If proven, these activities constitute a violation of the Redbook, parentheses, 650-RICR-20-00-1, close parentheses, specifically CRMP sections 1.1.11, comma, section 1.3.1, parentheses C, and section 1.3.1, parentheses G. Located at plat 369, lot 108 at 605 Budlong Farm Road, Warwick, Rhode Island. And Brian, I believe you have this. If I could just ask, who's got this? Mary, Attorney Chikachi?
Good evening, Mr. Chair
Good
and
evening.
members of the council. My name is Mary Shikarchi and I represent the respondent.
Okay, and Brian, if you could give us an update.
Yeah, thank you, Mr. Chair. The property owner submitted an application July 18th, 2022 to install structural shoreline protection, a riprap wall. Permit staff requested that they revise their plans they submitted to turn it into a hybrid wall, so stone at the bottom and vegetation at the top. Staff did get that plan. They worked on the application, it was drafted and it was ready to go out. Prior to it being issued, we got a complaint that work was being done on the property down by the water. I did a site visit and found that work had been undertaken, the earthwork, construction of the riprap, construction of timber structures, cutting of natural buffer vegetation, and earthwork in the intertidal zone. I issued a verbal cease and desist order to the contractor on site, explaining that no work was allowed, everything had to stop. He agreed to stop. April 7th, I issued the cease and desist order and an $8,000 fine to the property owners. On April 23rd, 2023, The fine was appealed by attorney Paul DeMarco. On May 3rd, I spoke to him, and then over the next several months, we tried to schedule a site meeting between the attorney, myself, their engineer, and the property owners. I wasn't able to schedule that meeting. I went back out on September 25th and found that they went back to work and the wall was completed. And the way it was completed was like the first plan that was submitted. So it's all riprap. So we issued a $10,000 fine, notice of administrative fine on September 27th. And that was appealed on October 16th, 2023. On November 28th, 2023, we held a meeting at the office with attorney Paul DeMarco, their engineer, and their contractor, explaining what needed to be done to resolve the violation. I sent them a letter on March 12th, 2023, requiring that a plan come in by April 5th, 2024, and with restoration of the site by May 24th. Subsequently sent another letter extending the deadline to saying that we had extended the deadline to April 15th, 2024, and that date was not met. So we were going to schedule the matter for a hearing. Around that time, attorney Archie took the case over from Paul DeMarco, and we've been working on resolving it. We had a meeting at the office with Director Willis and Deputy Director Miguel, myself, Mary, and we came up with what needed to be done, I think, to resolve the violation. But we haven't gotten a restoration plan or anything that we could approve to resolve the violation. So we scheduled the meeting for today. Mary Shikashi sent in a packet with a proposal on Friday last week. So that's why we're here. We're trying to get some hard deadlines set for restoration or an acceptable application to be submitted.
Thank you. Any questions of Brian from the council? Attorney Shikachi, anything to add?
I just want for clarification, we didn't really meet on this matter. We were there on another matter and then you brought it up, because I had just got involved, just because I'm thinking, I don't remember the meeting. Yeah, I know we had briefly discussed some of it.
It kind of morphed into.
Right, exactly. Okay, so I just want to clarify that, because I didn't have any notes. I know we discussed it, that it was something I usually got involved in. I have nothing to add, I think, other than just a clarification on that meeting. Brian has given the facts as I know them as well. I would say that we did submit the restoration plan or the documentation, which was quite lengthy. I received it, I think, last week from our engineer, and I had to send it, the size of it, Federal Express it over to the council. So they only got it staff on Friday. So I apologize for that, but that's when I received it. Based upon that, I just had requested a continuance of 30 days. So you could have an opportunity to review it and respond to us, so we can hopefully get some dialogue continue based on data to proceed forward, to hopefully get this resolved. That's our position.
Any questions of Attorney Shikachi?
So,
Mr. Glenn?
given that there were two cease and desist orders here, the second one comes after the first one, obviously, and work continued and the fine got increased. What happens with the payment of the fine at this point? Assuming we have a restoration plan that staff approves of, does the fine get paid?
Schedule a fine hearing separately. It would be a different track. So we would go through this, like resolve the violation this way, but the fine would be handled by the hearing officer.
Okay. Well, what would be the justification for not enforcing a fine by the hearing officer?
That would be up to
And how long does that take?
to have the hearing,
Yeah.
or to schedule it. We would schedule it we would try to resolve this part of it first
Mhm.
and then schedule the hearing, but we could schedule it at any time, but I think in this case, it would make sense to try to get the violation itself resolved
Mhm.
and then proceed with the course. So
Thank you.
Thank you. Do we need a vote on anything? I know we're here for just a conference. She's asked for a 30-day.
I think a vote to continue would be pretty much the extent of what you can do here under a status conference. So whatever the council's pleasure for continuing it to a date certain.
Do we need a date certain or just allow them a continuance?
You could just continue without continue until further notice from staff.
Okay.
Something along those lines.
Did Brian mention he wanted to, one of the things was set deadlines for the restoration?
yeah, they got something that we can approve. I don't know if we can approve this yet. It's not an application or anything, it's kind of like a concept of what they want to do. So if they want to do this and they want to apply for it, then we need a deadline for that to come in.
Just so you know, respondents not opposed to that. That's why I just had requested 30 days. And they got this so late, giving them the ample opportunity to review it and respond. So I'm hoping that a response would say, no, come in and meet, or this is an issue of, typically, that's usually what happens, is that we start the dialogue and address their comments, staff's comments as best as we can. If they have deadlines, we usually follow those. So.
Brian, would
Yeah,
you
the
recommend
communication.
setting a 30-day deadline for the application to
Yeah.
restore?
Well, it wouldn't, if what they're proposing wouldn't be restoring it. It would be to apply to get permission to keep what was put in.
Wasn't there originally a plan that you did approve of?
Well, the permit staff had drafted the asset and they were approving a plan.
And then they went and did something else?
Yep.
Well, why wouldn't we just go back to the plan that had been approved? Wouldn't that be, I mean, to then go build it sounds eerily similar to another recent case we've just had. So I would not be in favor of that. I mean, I'd be in favor of going back to what the applicant had originally said they would do and then apparently didn't do. And then to make it worse, went back after they got a cease and desist and continued doing it. So I mean, I know you haven't had time to review the plan, but the idea that somehow a plan to bless what has been done after 2 cease and desist orders, to me, seems to be flaunting rules. That's my opinion.
May I just clarify something? The assent was never officially issued, correct?
No.
Okay, thank you.
So there was no assent to do anything?
Nope.
Yeah, I think starting ground zero.
Thing I'd like to point out, the plan that was about to be approved and issued, and the permit that was going to be issued, the toe of that wall at the bottom was in one spot. And the stone that was put in with the wall that was built is about at the most 9 feet farther seaward. And it's it's less than that in other places, but it's so much farther out that if they did get permission, I think, to get a wall there, a full wall, it would have to be brought back anyway.
Deja vu. What's the pleasure of the council? I mean, I think they're asking for a 30-day continuance to allow our staff, obviously, to review what's been submitted. I think it's key in response to a question by Attorney Shikachi that no assent was approved or came out yet. So to Mr. Flynn's question, I don't think they approved something, then they did something else. Maybe they were about to approve it, but we don't have anything that was approved. Yes, Mr.
No,
Willis.
we didn't have, what we did have was an application that staff had worked out with the applicant, and we were drafting the assent to approve a certain design. And then the applicant, before that assent could go out in a construction that we were acceptable to, the applicant built something different. So I think if we get an application back that's similar to the original application that we were willing to approve, that could be a path towards restoration. But what we got on Friday, correct me if I'm wrong, is not that. What we got on Friday is a narrative to keep what's in place right now. So it won't take us too long to review that and get back to Attorney Sakarchi on what would be an acceptable path to follow. I would recommend that give us a couple of weeks to review that, what we got on Friday. And from there, we can ask through Attorney Sakarchi, we can ask the applicant to respond in 30 days with a more appropriate application, similar, if not exactly, to the one we had back in 2022, I believe. Something that we, at that point in time, we were amenable to approving. Maybe site conditions have changed. It might need to change a little bit, but something similar to that might be a path to restoration that we can support.
So would it make sense to vote on an extension, not an extension, a continuance of this hearing for 60 days?
My interpretation of legal counsel's comment is that's what we could do tonight is
Yes.
continue for a time period.
Yeah, I'd like,
Right. I think that's reasonable.
I'd like to have a specific time period, not just leave it lingering out there
Great.
and bring it back before the council. So that we can maintain some oversight of the application and the enforcement action.
All right, would you like to make a motion, Mr. Izzy?
Yes. I'd move that we continue CRMC enforcement file number 23-0047 for approximately 60 days, whatever that meeting would fall. And have staff report back to us as to progress on an application or an order to restore or whatever staff deems is appropriate.
Is there a second?
Second.
Seconded by Ms. Reynolds. Any discussion?
Just one question. So within that, it probably won't take the staff 60 days to review that document. If it is in fact asking to keep what's there, it won't take 60 days for that. So within that 60-day period, for what Jeff has said, there'd be further activity to ask for a different sort of plan that would go back to the original plan that was ready for approval within that 60 days. Without
Yes.
waiting 60 days
No.
to hear the result of the review of that.
Within that 60 days, staff will review that, comment back through Attorney Sakarchi, who before that 60-day period is up, will get back to it. The applicant will get back to us with hopefully a plan that's acceptable for us to review.
Makes sense. Thank you.
Okay. Any further discussion? Hearing none, I'll pull the council. Mr. Flynn,
Aye.
Mr. Izzy,
Aye.
Mr. Russolino,
Aye.
Mr. Gagnon, Ms. Reynolds.
Aye.
I too, Raymond McCoy, vote aye. Thank you.
Thank you.
Jesus.
Says, like, you know, like when you get like Google text, it's like, get me out of it, like, I don't know. It's like- Okay, next matter on our agenda is 23-0222 Leonard T. Maynard Trust Agreement. The alleged violations are the unauthorized construction of a riprap retaining wall and stairs on a coastal feature, earthwork, filling, removing, and grading, clearing of a natural buffer zone vegetation, construction of a fence, and installation of an impervious surface on and within 200 feet of a coastal feature. If proven, these activities constitute a violation of the Redbook parentheses 650-RICR -20-00-1, close parentheses, specifically CRMP sections 1.1.11, sections 1.3.1C, section 1.3.1F, and section 1.3.1G3C. Located at plat 369, lot 109, Budlong Farm Road, Warwick, Rhode Island. And we have Attorney DeVideo here. And Brian, you have this one as well? Thank you.
Thank you, Mr. Chair. The same day that I went out to the previous one we talked about, April 3rd, 2023. I inspected the site. It's adjacent to the previous property we just talked about. This site was being used for access down to the water. They were doing unauthorized activities for earthwork, cutting of natural vegetation, earthwork in the intertidal zone. I issued a verbal cease and desist order to the contractor at the site. He agreed to stop. They told me to stop all work. I didn't issue a cease and desist order to the property owner at the time. They weren't the ones doing it. It was associated with next door. But then when I went back out on September 25th. Oh, I should put up Paul DeMarco, also represented this property owner at the same time. When I went back out September 25th, 2023, I found that a wall had been built there also. There was a riprap retaining wall that tied into the neighboring property. September 28th, a cease and desist order and a $10,000 notice of fine was issued. November 28th, 2023, I met with Attorney Paul DeMarco, the engineer and the contractor, the engineer who worked on the one next door. And we discussed what needed to be done at this site to restore it. And I sent a letter March 28th, 2024, requiring a restoration plan be submitted by April 15th of 2024, with restoration of the site by May 24th, 2024. On April 29th, 2024, I sent them a letter stating they hadn't met the deadline and that we would schedule the matter in front of the council. Attorney DeVideo took over the case from Paul DeMarco at the time. Shortly thereafter, we spoke a couple of times when we met on site September 30th, 2024, discussed what needed to be done. October 21st, I sent an email to Attorney DeVideo setting a November 22nd, 2024 deadline to submit a restoration plan. January 13th, 2025, we sent a letter stating the plan hadn't come in and that we were going to schedule the matter for tonight. And then on January 27th, 2025, we scheduled it for tonight. This one's a little bit different than next door because there's no house on the property. So structural shoreline protection is prohibited. So we're looking for restoration of the site, which could mean a non-structural shoreline protection to protect it. But they wouldn't be able to apply for this.
Okay.
In a similar situation, we're trying to get a hard deadline set for this stuff to come in.
Okay, any questions of Brian from the council? Yes, Mr. Gagnon.
So I'm looking at the aerial photo that shows both lots. Where does the like unauthorized fill end? There's a second stairway, is it end about there or?
So photo number 2.
My page 13 is 1.
It's the photo with the walls shown.
Yes, both walls.
Yeah, all, this lot is the one on the right of the photo. So those lot lines don't really line up. So it's the stairs on the left, well, the middle stairs on the photo come off of the Leonard Maynard property.
So the wall that's kind of curved on the adjacent property, that's not a violation.
Correct, that's permitted.
So it would have to tie into that, so. Whatever the restoration is. As well as the, if something gets built on the other property, they'd have to somehow tie into that.
The stairs on the far right in the photo where that property owner was issued a violation for the stairs, but we're kind of waiting to see what happens with this first, because the wall comes out, the stairs are gonna fall. Like we don't want him to be applying for it yet, but he's gonna need to at some point. He might have to change the orientation.
Thank you.
Any other questions of Brian? All right, Attorney DeVidio.
Yes, good evening, Chair,
Oh, yeah.
and members of the council, staff. I represent the Maynard Leonard Trust Agreement. I'm gonna get some of the background to this matter. So, Leonard Maynard, he operates Buttonwoods Campground. He's been doing that for many years. He's in his 90s. And suffice it to say, his daughter now has power of attorney. Draw whatever conclusion you like. So in order for me to get on board with this, it took some time to make that connection. And as soon as I did, I had a site visit with Brian. Devin Robinson. Yeah. Immediately reached out, this is the end of September, to retain consultants. Plus that, bringing us close to Thanksgiving. Was able to get some contracts prepared and in place. I did ask and tell Brian that, I'm trying the best I can to get this restoration plan. It wasn't ignoring the situation. We finally do have contractors in place, an engineer, surveyor, and a biologist. They all have been out to the site. The surveying work is going to begin or has begun. There are there are 4 different locations, violations. We're here only for one tonight, which is 109, which is the most egregious one. I'll just say as an onset, we fully intend to comply with the CRMC regulations. In particular, the full vegetative restoration on all matters that are in front of the council, but particularly the one that's on tonight for lot 109. We've only asked that we have an opportunity to submit an application, it would be a structural, non-structural wall, and Ron and Brian alluded to this for 2 reasons. One, without any sort of support there, that properties is going to continue to erode. And you can see that erosion is also wrapping around the wall to the east, where the stairway is, which was unpermitted, but that was a permitted wall. So if we don't do anything there, A, our property is going to continue to erode, and B, whatever is done on either side, whether it be 108 or 110, they're going to continuously have problems with erosion on the tail end of their walls. So that jeopardizes obviously 110, which is the principal use above. So whatever we do, even if we just did a full restore, we have to integrate that into what's happening on 108, Mr. Carter's client. We can't just rip out what we've done without coordinating from at least an engineering perspective, what's going on lot 108. So we're going to be developing proposals, hardened or non-structural solutions. If they're rejected, we just pull it out, we restore and let 108 and 110 do what they gotta do. But certainly, we can't just rip out 109 because it is tied into 108 and partly into 110. Less of an issue, but certainly 108. Now, what is most troubling, and I've spoken to council and Brian Harrington, I think that the full council should understand and appreciate this. This contractor, my client has been operating this campground for, I don't know, decades on a handshake. The businessman, but not particularly up to date on what regulations and all that require. He hired this contractor to do the work with the trucks that he knew what he was doing. When that cease and desist was delivered to my client, he notified the contractor. Contractor said, don't worry, I know people down at CRMC, I'll take care of it. Went down, knowing that he shouldn't be doing what he was doing, and continued the work anyhow. Now, your regulations allow to issue a notice of violation against anybody who violates the state law or your regulations. This particular contractor should be brought to heel for two reasons. Number one, if he is cited and has a violation, it'll help us get this work done cheaper and quicker, versus going out to get someone else. So, but whether or not you choose to do that, I think it's good regulatory and public policy to not let someone thumb their nose at the council. At the detriment, obviously, to the environment, wasting all of our time here, and my client, a 90-something-year-old man who now needs a power of attorney for all his affairs. Wasn't that long ago where he engaged this contractor to do this work. So what we're looking for is the appropriate amount of time to submit, or at least to begin to develop what we might want to do. And that's going to have to wait till we find out what's happening on 108 and see how we can proceed with anything until we find out what's happening. So if we could continue this for 60 days along that good faith representation, that either we take that all out so that it doesn't affect what happened in 108, do a full restore, or we do something short of a full restore.
Questions?
Attorney DeVidio, I assume you're still in contact with CRMC staff, Brian?
Sure.
And where, I just want to get a sense of where you and your client are in the development process, the engineering process, figuring out what your next steps are and how long, and if you have an idea of how long it's going to take to get something to Brian to review what Attorney Saparchi's client is talking to.
Sure. So I think we probably can put forth our vegetative restoration plan. I don't think that whatever we do is gonna, we've got to replant what was removed. So that's pretty straightforward.
Yeah.
As I said, we have Decreed Engineering is doing the survey work for us. CCE, Tom Nicholson, the PE, he's been out to the site. Joe Klinger from Ecotone's been out to the site giving, and the engineer, Tom Nicholson and Joe Klinger are brainstorming about what's going to be the best approach to dealing with this. I understand that without a principal use of structure, if you will, there's a flat prohibition, but I want to remind well, Brian, or at least the staff, that Budlong Road, private road, services all those homes along there. That's a principal structure, principal use that is in jeopardy at some point from erosion of this parcel. And the house on 110 is very close to the property line. And this erosion on the tail of his permitted wall is going to be in jeopardy if nothing is done. But so that's the thought process of our engineer and consultants generally, that there really should be something done just as a matter of good engineering and environmental practice to protect these two walls as well as my client's parcel, which again, at the road, which services that entire stretch of the beach. So that's where we are. They're still looking at it. They're in the conceptual development stage. Kind of as a chicken and egg sort of a thing, like, well, how far do we go with the concept until we find out exactly what's happening with 108?
Well, Brian, would it make sense if we were to continue this hearing for 90 days? Put an extra 30 days to kind of catch up to what ODI is doing.
Might be a good idea, just so everybody's on the same page.
Yeah.
We could also meet, like all of us could meet.
Well, yeah, you,
On our own, like
look, you're gonna continue to do your work, but and I would assume it's talking with the applicants, with the property owners, but obviously we're not involved in that process. I just want to keep a handle on the council's involvement and responsibility with respect to these enforcement actions. But you think 90 days makes sense?
I think so, yeah. Because it'll give a buffer for this, once the 60 days is up and we have an idea of what's going on next door.
And then you can circle back and coordinate. And talking about coordination, did the same contractor work on both of these properties?
I believe so.
It looks, I mean, just looking at the pictures, it looks like the same one.
Well, as you said, he came in with Tomaco, who was representing 108 and 109 at the same time. Problematic from an attorney's perspective, but suffice it to say, he was there. He admitted to you in that meeting, he saw the equipment and he admitted he did it, and basically said, what's wrong with what I'm doing? And after you told him how we need a permit, I'm paraphrasing, went out there and completed the work. That's pretty bold.
Twice on two properties.
Well, so 108, 109, and then he went further down on my client's property on 111, and he made a big mess down there, where in order to get his equipment off the beach, I got pictures, I got a video of the waves splashing up. They had to have this big piece of equipment, drag his equipment up the embankment, which damaged the embankment, which caused him to put in rocks, which were a violation.
So the question about, I'm glad you asked the question about citing a contractor. What is our policy on citing a contractor? This might be a good case.
Right, we do have the ability to cite contractors for work when we have evidence that they were the ones doing that work. That's when we have done that. We haven't done it regularly. It's I'll ask enforcement to correct me if I'm wrong. It's happened a handful of times over the many years.
Well, this case seems pretty willful, both cases. And contractors should know better. They've dealt with the coast. They know that there are rules. In this case, getting a cease and desist on two separate properties and ignoring it. I don't know how much flagrant it has to be, but that seems pretty flagrant to me.
All right. As it relates to the application before us this evening, Mr. Izzy, are you making that motion that you stated?
I would make a motion to continue this matter for 90 days to the next appropriate council hearing date.
For a second?
I'll second.
Motion made by Ms. Izzy, second by Mr. Flynn. Any discussion? Hearing none, I will poll the council. Mr. Flynn.
Aye.
Mr. Izzy.
Aye.
Mr. Russolino. Aye. Mr. Gagnon. Ms. Reynolds.
Aye.
I too, Raymond Coy, vote aye. Matter will be continued as indicated in the motion. Anything else to come before us this evening?
There's nothing further on the agenda, Mr. Chair.
I would entertain a motion to adjourn, please.
So moved.
Motion made and seconded. Any discussion? All in favor, say aye. Aye. Meeting is adjourned. Thank you, everybody.